So the jury is being selected right now as we speak in what would be probably the trial of the year, maybe even the trial of the decade. It's the George Floyd Derek Chauvin case. So I want to thank one of my subscribers. His name is El Gallo Loco. He suggested that I do this video, and what he was wondering is what my thoughts were about the jury being sequestered, or the partial anonymity order that the judge put on the jury selection process. So I'm going to share my thoughts about what I think about it, and I think the best thing to do first is to at least read what the order says. So I'm going to read some relevant parts of it, and then I'll go on to talk a little bit about what I think about it. So just for context, I'm going to read a couple of points that the judge makes in a section of the order called Findings of Fact. And this is basically the historical background that leads the judge to believe that there's a reason for this anonymity order. Defense attorneys have expressed concerns for their personal safety and the safety of their clients, and the court finds those concerns credible. Number 5, in an obvious attempt to intimidate persons involved in this case, some protesters have picketed the homes of at least one defendant, the head of the police union and the Hennepin County attorney. The county attorney's home was also vandalized during the period of civil unrest following the death of George Floyd. Number 8, it is highly likely that persons with an interest in this case may also attempt to contact jurors in this case and argue for a specific result. Such communication would be improper, and all reasonable means should be taken to insulate the jury from such contact. Reasonable measures in this case include having an anonymous jury and some sequestration of the jury during the trial and deliberations. Number 9, strong reasons exist to believe that threats to jurors' safety and impartiality exist in all 4 of these cases. Then they go through some conclusions of law, and then the court gives its order. And here's what the order is. District Court Administration shall not divulge prospective and selected jurors' names, addresses, and other identifying information except to attorneys involved in the litigation of this case. Attorneys who receive prospective and selected jurors' names, addresses, and other identifying information shall not disclose that information to anyone except their clients or employees and contractors working with the attorneys on this case. So I'll talk a little bit more about that in a second. Down to number 4, the jurors' names, addresses, and other identifying information shall be kept confidential by the court and all parties throughout the trial and deliberations. At the conclusion of deliberations, jurors' names and some contact information shall be made public only by the court and on a date designated by the court in a subsequent written order. I'm going to talk a little bit more about that also. And I'll link to the actual full court order in the description if you want to take a look and read the whole thing for yourself. So the first thing that I'll say about that is, if I were a juror on this case, I would not serve unless the court would assure me that they would never release my name or any identifying information about me to the public, that this would be sealed forever. I saw what happened during the summer after the death of George Floyd. $2 billion worth of damage. 19 people were killed. So imagine what would happen. I mean, I'm thinking as, from the perspective of a potential juror in this case. Imagine being on that jury. What happens if at the end of the trial you find that Mr. Chauvin is not guilty? I mean, you think about it. Stranger things have happened. O.J. Simpson, he was found not guilty. What do you think people who were willing to riot and to kill based on what happened to George Floyd, what do you think they would be willing to do to a juror who didn't find the way that they thought that they should find? So that's the first point. And the second thing that I want to say is anybody who thinks that intimidating or threatening lawyers, witnesses, jurors, anybody who thinks that that's okay, that's a threat to the rule of law. And once you threaten the rule of law, you threaten the stability of our society. And anybody who thinks it's appropriate to threaten or intimidate lawyers, witnesses, jurors needs to be condemned. So while it's a nice gesture that the judge is going to keep the names and the addresses and the identifying information of the jurors anonymous, at least for the time being, I can tell you, or at least the prediction that I would make is that this information is going to get out. And I have 3 main reasons why I think that's the case. I hope I'm wrong, but I guess only time will tell. So the first reason is, you think about it, these jurors, or these potential jurors, are going in and out of this courtroom during the jury selection process every day. So anybody with ill intentions or the desire to dox these people who's paying attention and is a little bit savvy, it's not going to be that difficult to figure out who these people are. The second reason why I think that the names will probably get out is even though the jurors' names are not being used during the jury selection process, they're being identified by their juror number. I've read so many news articles on this case, and in the newspapers, they provide identifying information. We know the race of these jurors who have been selected already. We know the gender of these people. We know what they do for a living, even very specific information about what these people do for a living. So just a few more pieces in the puzzle of who these people are. That leads me to believe that their information is going to get out, and the public is going to learn who these jurors are. And the third reason why I believe that the identifying information of these people who are actually going to serve on this jury will get out to the public is, so I've picked many jurors, and I know how it works. And let me just read back again from the order from the court and read the specific language. It's important. It says, attorneys who receive prospective and selected jurors' names, addresses, and other identifying information shall not disclose that information to anyone except, and this is what becomes important, except their clients or employees and contractors working with the attorneys on this case. So you've got the clients. And so the way this works is the court will photocopy the jury lists, which contain the list of the names of the potential jurors. And a lot of times there's addresses on that list, and there are phone numbers on those lists sometimes. So the court will make photocopies for each party, which contains the trial team. And then the part that it says the trial team's employees. So you've got paralegals, and you've got, here it also says, and they're contractors. And so when I pick a jury, I'm a contractor. So I get a copy of the list. And when I pick a jury, oftentimes we do social media searches on these folks. So sometimes there's 50 potential jurors, sometimes there's 100 potential jurors, sometimes there's even more. I can't do all that work on my own, so I have to contract with people who will work for me and dig through the social media, the Facebook, the Twitter, LinkedIn accounts, things that people have posted, blog posts they've written, any sort of social media that's out there on the internet. That information can really help you get a flavor for who this person is, what's important to them, positions that they might advocate for. Are they pro-police? Are they anti-police? Do they support causes like defund the police? Or are they Blue Lives Matter? Are they Black Lives Matter supporters? All these things are important, and that sort of thing, they might not talk about it as freely and openly in open court, but in their social media, people are very vocal about what they think. So I would have a whole team of people digging through the social media and the background information of these potential jurors. So you've got the trial team, you've got paralegals, you've got employees, and you've got contractors. You've got many sets of these jurors' names and identifying information. So the more people that have copies of these lists, the more likely it is that the names and identifying information of these folks is going to get out. So I want to make one more point when it comes to the actual jury selection process. So in this case, the jurors are being pulled into or called into the courtroom one by one and questioned one at a time by the attorneys during the jury selection process. So when I pick a jury, or when I'm helping attorneys pick juries, I'm looking at the whole group of potential jurors in the courtroom at the same time. And so when one potential juror is being questioned, I'm paying attention to that juror or potential juror, what they say in their body language, demeanor, their tone of voice. But I'm also looking at the other jurors or potential jurors in the courtroom. How are they responding to what that juror might be saying? Are they nodding in agreement? Are they shaking their head in disagreement? And I use that information oftentimes when I'm trying to help the attorneys decide which jurors we should ultimately move to strike. So in this case, the attorneys picking this jury are missing that element of kind of the dynamics that happen in a normal jury selection, which is really going to make their job even a little bit more difficult. It's difficult as it is in this case, but that will make their job a little bit more challenging. So I hope you enjoyed this quick video. I'm going to make another short video on the actual jury selection process and the kind of the questioning style of the attorneys in this case, and I'll be uploading that one shortly. So I hope you enjoyed this. Subscribe, share this video if you found it interesting, and I will see you next time.